This morning in this session, we're going to concentrate on this issue of technology in the courts, and as the title for this session says, we're going to talk about the impact of a new Supreme Court rule on use of digital tools in Kansas courtrooms. And I'll introduce our panelists in just a moment, but want to give you some idea of how we propose to go through this subject. First of all, as Ron Kiefover indicated in the folder, I think it's right behind the agenda for the day, there is a copy of Rule 1001. That's a newly amended rule, and that's the rule on which we will focus in this particular session. And then we were going to begin our conversation with some discussion of a specific example of the kind of problem that arises in the use of digital tools. And we have in mind talking about an incident that happened here in Shawnee County not too long ago, where live tweeting from a courtroom resulted in a declaration of a mistrial. After that, we'll talk a little bit about the conditions under which a mistrial may or may not be declared in circumstances such as this, and the reasons for mistrials and some of the practices regarding mistrials. And after that, we'll discuss the variations in local court rules on or practices in how digital tools are used in courtrooms. And we'll then talk about why the Supreme Court amended this rule, Rule 1001. And after that, undertake a general discussion about the rule and how it may affect media coverage of courts in the future. So, with that, let me now briefly introduce our three panelists. And these panelists have distinguished themselves in their professional lives, and I will, for the sake of time, not go into all the detail that I could, but do take it from me, these are highly accomplished persons and widely recognized for their contributions to their communities through volunteer activities as well as professionally. First, on my immediate left is Liz Montano. She is a very experienced journalist. She began her broadcasting career in 1982 at a Salina, Kansas radio station. She served as an embedded reporter in Iraq in 2004. She has been communications director for a member of Congress. She's been news director at WIBW-FM, morning co-anchor and assignment editor, and this year she launched a weekly show titled Women Matters. Next, in the middle of our panel is Melissa Brunner. Melissa anchors the Live at 5 newscast at WIBW-TV. She also appears on news shows at 6 and 10 p.m. Her first job, it turns out, in the business was with a Wisconsin radio station doing fishing reports, possibly the most important work Melissa has ever done. How are the fish biting, right? That was a subject you covered. She then became a television news producer, and in 1996 she came to WIBW. Her experience is wide-ranging. It includes news reporting on such subjects as crime, the legislature, and health. And then on my far left is Justice Eric Rosen. He's a Topeka native and has been a justice of the Supreme Court since 2005. He previously had served 12 years as a state district court judge in Shawnee County. He handled criminal and civil matters. And for 2 years, he was chief judge of the district court's domestic division. Before becoming a judge, he engaged in private law practice, served as Associate General Counsel for the Kansas Securities Commissioner, and as an Assistant District Attorney and Assistant Public Defender in Shawnee County. So with that, I'd like to begin our discussion panel. And our first topic is this incident that I mentioned earlier. So we basically had a reporter for the Topeka Capital Journal covering a case. And in the process of covering that case, the reporter was tweeting live from the courtroom and took a photograph and posted that, and inadvertently in the process made available on the World Wide Web the image, identifiable images, as I understand it, of a juror. And to what extent, and I'd like to just kind of talk generally about this as an example of the kind of problem that concerns the judiciary, is how can a reporter take sufficient care not to let this kind of thing happen? We have in the Supreme Court Rule 1001 a prohibition on taking photographs of, at least photographs that make the jurors identifiable. What kind of precautions are necessary to avoid having this happen?
Well, I'll start by saying I know the reporter, and she felt terrible about it. So it was not a deliberate action. And in looking at the photo, if you didn't realize that was the juror, it was one of those things where it was, I believe, the defendant in the foreground, and then there were people in the back. And if you didn't realize they were the jurors, you wouldn't necessarily know they were the jurors. I think, and one thing that would be helpful, how many people here are primarily television reporters? Okay. How many people here are primarily print reporters? Quite a few. How many are primarily radio reporters? Thanks. And is anyone here strictly web-based? A few of you. Interesting. What it illustrates is the multitasking that is now required in the media industry. How many, and I said primarily print, how many of you primarily print people now find yourselves taking photographs and video? Yeah. And that's what's happening. It's incumbent upon the media to make sure that everyone is properly trained. Gone are the days when you had a strictly television photojournalist or print photographer going to the courtroom and they knew all the rules and they knew how to frame things and they always paid attention to everything that was framed up in that shot. Well, now the reporters are taking their own photos and they're taking their own video. The print people are taking video to put on the web. It's the whole meshing of new media and traditional media. And those of us who, I sometimes wonder why I'm on some of these panels, and then I realize, oh, I have been doing this 18 years. Maybe hopefully I've learned a thing or two. But it's incumbent on those of us who've been around a while and know the rules and the traditional way things were done to make sure that we're actually seeing value in the younger journalists who've grown up with all this new media, and it's just a part of their lives and how they use it. And how do we make sure that those two things don't create a situation where we're violating rules or jeopardizing a fair trial? So I think that is what that situation is an example of how we all need to be aware that everyone is multitasking and that everyone is trained in the rules and what to look for in composition. Liz.
And Liz, go ahead. Do you have a thought on this subject?
No, I totally agree with what Melissa just said. I think that as we have evolved into a more social media type of society, that we absolutely must be cognizant of the different forms of media that we are going to be practicing within the courtroom especially, and to have the appropriate training in the first place. I totally agree with Melissa that as the newer generation of reporters come up who have always had this within their realm of possibilities, that the elder journalists need to help them learn the ropes, but that there needs to be more training, perhaps in colleges, et cetera, in dealing with this particular type of medium that we have at our disposal today.
Now, you must both feel it's important to have live coverage and would value the opportunity to use tweeting or some other means of reporting on the proceedings as they occur. Could you share with us how you see that value? Why don't we just wait until the trial is over and then report what has happened on the basis of personal observation? Why is it so important to be in there with the live coverage?
Well, I think partly it's because it's the demand of the world today, the immediacy of the information that's going out, especially in very high-profile trials. So absolutely, I feel that it's important that we have the ability to report as things are going along. I totally believe in transparency in any governmental or court institution, but there are responsibilities that go along with that, and we have to abide by those responsibilities.
And we have to realize on both sides that one doesn't cancel out the other. We had a preliminary hearing, a set of proceedings in Shawnee County where the judge decided, and it really was a progressive decision in terms of the initial decision, which was he would only allow it to be covered via Twitter, which on the one hand actually ended up, I believe, giving a lot more information, especially from a television standpoint. If you allow the tweets and the Facebook updates to go along with the 1.5 to 2 minute report that you're going to end up seeing on the evening news, I believe it actually ends up providing a more complete picture of what that proceeding entailed, because you're getting the play. We don't have time on the evening news or even in the newspaper or on your radio broadcast to say every single thing that every single person said. But if you allow that live tweeting and that live streaming, and by streaming I mean even just the word stream, you're going to end up getting a more complete coverage of what actually happened in that case. But it also has to complement the broadcast. The downside of allowing that proceeding to only be covered via Twitter was that no cameras were allowed, audio, visual, or still, which then kind of compromised the coverage on the other end. It makes me think of that really dramatic legal movie, My Cousin Vinny, you know, where in court the prosecutor comes up and says, so the officer said to you, you shot the clerk, and you replied, I shot the clerk. But if you recall in the scene earlier, the officer said, you shot the clerk. And he said, I shot the clerk? You're not going to get that in simply words, you know, in the written word. It's the power of the visuals and actually being able to see and hear, and I know we're going to get into more of that later.
Go ahead, Justice Rosen.
First, let me preface something. It's been, as Professor Kautsch pointed out, I was a trial court judge from 1993 until 2005. So I'm 7 years removed from some of this technology and the progress that's been made in this area. 7 years removed, at least in a trial court context, where I think that's where the challenges are. Here in the Supreme Court, yes, we have some challenges about how things are covered, but I think the real issues occur in trial court. So part of when I was there, I was dealing with BlackBerries. That's what I remembered, people using their BlackBerries and how we were going to control that, and that was about it. And we've progressed so far since that time. But a lot of things have kind of percolated in my head, just hearing some comments, is over that 13-year period that I was there, I was able to, at least in terms of how courtroom proceedings were covered, and I think some of the camera people are still with you and with KSNT and the other local outlets here, is that I was able to establish somewhat of an understanding and a working relationship with some of these people that didn't cross the lines of impropriety in terms of what was happening with the court proceedings, but at least in terms of what was tolerated and what was not tolerated under our formal rule. And that worked out pretty well. The understanding of who could be recorded, who couldn't be recorded, where they would sit, attire, those kinds of things, to try to keep some semblance of decorum in the courtroom, which is one of the challenges of a trial court judge or anybody overseeing the proceedings. So that's kind of an interesting component that you don't necessarily have that luxury in probably larger markets or in a different market where you have different people you're working with. And just remember that the other thing I want to keep in mind is we're all for the First Amendment. I mean, everybody in this room, and including every justice and judge in the state, understands the First Amendment, but it doesn't stop with the First Amendment. And remember, especially in a criminal proceeding, there's a whole host of other kind of tensions that are created with the Bill of Rights. You have the Fourth Amendment, you have the Fifth Amendment, Sixth Amendment, which deal with kind of the trial proceedings, rights of accused, and sometimes the interplay with what is covered and what is allowed in a court proceeding and the prejudice that can result is all part of the weighing and all the part of the consideration that we have to give in court proceedings. And as I look back on my time in doing that, I think my biggest challenge wasn't so much the trial proceeding, because that's when the evidence is coming out. You've had your pretrial rulings. Pretty much there's always stuff that happens that you don't anticipate, but pretty much controlled. But it's the pretrial proceedings that are really difficult in trying to control what information is gathered, what's recorded, what isn't recorded. You're dealing with suppression issues, prior crime issues, all kinds of things that can result in have a prejudicial impact on the trial. So just for questions and those kinds of things, I'll welcome those. But those are kind of the tensions that I felt that I dealt with with the challenge of balancing all of this.
Well, perhaps we can take advantage of the points you've just made by referring to the specific rule that was at issue in this case where the live tweeting resulted in a mistrial. The rule was, and we find this in Rule 1001, a provision there, individual jurors, the rule says, shall not be photographed. In courtrooms where photography is impossible without including the jury as part of the unavoidable background, the photography is permitted, but close-ups which identify individual jurors are prohibited. Okay, so that's the rule, and that's the rule under which the problem developed, because the photograph was a product of live tweeting, included this identifiable juror image. Now, Liz and Melissa, you've made a good case for the use of these devices to report live on the proceedings. Why shouldn't you be allowed to go ahead and photograph journalists? Does that make, or jurors? Does that make any sense to you that you're prohibited from that? It does, Liz.
It makes sense to me on a number of levels. I think that first and foremost, the biggest concern I would have about jurors being able to be photographed would be, especially in a trial that is perhaps of some type of violence, where the juror could be in danger by being identified. I think that that would be one of my biggest and first concerns. I actually, when I was called upon for this, and I thought it was a tremendous opportunity, and thank you for that opportunity, but I spoke with a number of other reporters. I said, this is what we're going to be talking about. I would love other people's input on this before I go in that day. And the input that I got was really across the board and very much surprised me. And these are working media people. Most of them would consider themselves actual reporters or journalists. And certainly others have been in the industry long enough and have covered different media events. So I respect their opinions. And I was actually very, very surprised at the gamut that this ran. In some instances, one of the quotes was that the court is sacrosanct and that there should be no social media in the court at all. That really surprised me, and we argued about that for quite a while. As far as photographs or video, then it was just at the level what should be allowed. Maybe it's without the jury in the room at all. I mean, and so there were just different proposals that I thought was quite interesting,
Mm-hmm.
and the fact that it was journalists that had this entire range of opinion, and it wasn't all by age either. It wasn't that the older journalists thought, okay, maybe we shouldn't allow the social media in the courtroom. In some cases, it was the younger journalist that was concerned about how it might compromise the court or the trial.
Melissa, do you have a view also on this? Why should you be prohibited from making an identifiable photograph of a juror?
I think that journalists all understand the need for some restrictions in some situations. What gets difficult is when there are different rules in different courtrooms and different restrictions, and this can be done here, this can't be done there, when can you do this, that's where the training gets very difficult and complicated. But specifically for jurors, on the one hand, there's the view of, anyone can walk into that courtroom. Anyone can walk into that courtroom and see those jurors. On the other hand, I do feel that the jury in particular is a little bit different because, especially if they're not sequestered, they're the ones who then, they're making the decision, and they're the ones who could face, and this is going to sound odd because I have maybe a little bit different view when it comes to some of the witnesses, but they're the ones who perhaps are voluntarily making a very difficult decision that could put them at risk. They could be swayed, especially during the proceeding itself. They are the ones who could be swayed to decide one way or the other. The witnesses are giving their truthful account, hopefully, of what happened. The jurors can be swayed. But again, anyone can walk in that courtroom and see who they are.
Let's try one more take on this. I don't know if you could imagine this, but let's try. Let's suppose one of the jurors is an attractive young woman, and the judge sitting presiding over the trial is an attractive young man, and you're sitting there with the opportunity to photograph inside this courtroom during proceedings, and you are convinced that the juror and the judge are flirting with one another during the proceedings. Now, Liz, wouldn't you be tempted to try to photograph that?
Oh, yeah.
Oh, see?
Let me comment. Yeah, no, of course that never would have occurred.
No, yes, hard to imagine. But
Just a couple of things about jury trials. You know, I presided over hundreds of jury trials in my tenure, and one of the things to keep in mind is how important the trial by jury is in our whole judicial administration of justice, but also what we're asking people to do. And it is quite, and I'm surprised. I was called for jury duty, and here about 2 years ago, and here I had been, you know, overseeing jury trials, was here, and it was an intimidating process for me. And I've tried to think about why that was, and part of it was I was being asked questions rather than doing the questioning. But just the whole process of being there with your peers and being called up to the jury box, being asked questions about reasonable doubt, burden of proof, even though I think I know some things about that, for me was an intimidating process. And the whole process is critical to the administration of justice. And we want to encourage and keep juries as impartial as possible. And if they think that they're part of the publicity aspect of the trial, I think that impacts that participation. I was going to make another point. Oh, bear in mind, we have 7 justices, and I'm the last one. I do not take a computer up to the bench. All my colleagues now do take a laptop up there, and I'm stubborn about that. And one of my colleagues joked with me that they're going to get me a quill and ink thing to write with. But I'm kind of stubborn, but the part of my problem with Twitter, and it's part of it, I don't necessarily understand exactly what it is, but it allows, and I think how it started was to give a present sense impression of what I am doing at the time. And why is that so important? I mean, we had a Twitter feed out of a case, and I think that's partly what motivated these rules, that the witness or the defendant was sneering. Now, why is that an important observation to make over the Twitter world? And I don't know why that is, and that's an impression that particular journalist had of what was occurring. That might not be what was happening, and that forms an impression and can at least prejudice the public outlook of what's happening. And again, I'm not as sophisticated with Twitter. I understand some of the other stuff, but I don't understand that. But that's my concern is that when you have this kind of present kind of recording of what's occurring, it's being filtered by someone who's just immediately reacting to a scenario which might not be accurate at all. Maybe not. Or but it's filtered through their impression and the biases and prejudices they bring. And a lot of times, and again, I'm probably all over the graph here, part of the challenge, I think, for you all, and I'm really glad you're here, is to get familiar with what happens in court. Because most of the time, reporters, and I'll say this is especially true with more of the TV people, at least in my experience, are not very familiar with courtroom procedures and process, really don't know what it is they're covering in terms of what is exactly happening in court. And therefore, and then you have this person kind of filtering that with a Twitter and not really certain of what even the burden of proof is in a preliminary hearing, what's occurring in a preliminary hearing or what's happening in this particular civil case. And that's my concern, is just kind of, again, from the judge point of view, is having some control over what's occurring in your courtroom. So again, that tension.
very good.
But if I can just say, that same filtering is going to happen whether it's on a Twitter feed or a newspaper article, a web article, or the television article, or the radio report. That same filtering is going to happen. Part of it is about being a responsible journalist and knowing. And also, I say this when people are watching the cable news stations. Are you watching a news program, or are you watching a newsotainment program? It's knowing the source, knowing what type of source you want to be for people, and being responsible about it. You're right when you talked about the level of trust that you as a district court judge had when we were covering it. There has to be a level of trust on both sides. You have to trust that the reporters are going to do the right thing, that they're going to be fair and accurate, and that they're going to know the rules and obey the rules. But you are right, there are a lot of people who are inexperienced in any one of those things down the line. And it's incumbent on everyone to police each other. As to why is a Twitter feed important, why is that Facebook constant updating so important? Simply because that's the way the world is. Sorry if it's not your world. But that is why newspaper circulation is dropping. That's why TV ratings are dropping. That's why radio has had to figure out a way to remain relevant. Their main way they're remaining relevant is because they're the instant update. You turn on that dial and right there they are. They don't have to worry about when the next printing cycle comes around or when the next newscast cycle comes around, which is what Twitter and the web have allowed TV and newspapers to do. I still subscribe to the Capitol Journal, but I don't really read a lot of it because I've read it all the day before as those articles have posted as they're happening. Same thing with our television stories and articles. If you're following our Twitter and our Facebook feeds, hopefully you're going to know the main things. And then that's going to complement the evening news and the next day's paper. You're going to say, okay, I want to see it all summed up in one nice, neat little package on the evening news. And I'm sure everybody's running into that. We're a newsroom that's very, very much focused on that social media. We kind of do a newscast on the side. But making sure we are updating people in those sources that they're using throughout the day, whether it be Twitter, Facebook, or our actual website, that's become the priority because that's how people are consuming news nowadays. But it doesn't set aside the fact that we need to be responsible and obey the rules and make sure we're being fair and unbiased.
I am in complete agreement, in fact, with all of that, actually, because initially when the whole Twitter debate became a debate, it was one of those things I was concerned about too. What if you do see someone sneering in there? Will it impact? But honestly, at the end of the day, you know, what matters is what the jury thinks about that particular defendant, and they're the ones that are going to have the fate of that defendant in their hands. So are they going to be tried outside of the courtroom through some of these things? It's possible, but I don't know that it's going to be any different than what it had been in the past. It just happens at a faster pace now. I completely agree that it's incumbent upon us as journalists to be very responsible in how we handle our reporting. And I think it would be extremely helpful if there were like rules in every courtroom so that there wasn't an issue. Should we do this? Can we do this? I don't remember if I can do this in this courtroom or not. I think if the guidelines were similar throughout the different courtrooms and there was more proper training of journalists before they go in to cover courtroom trials through the universities or their journalism schools, etc., I think that we can make this work and that we can keep up with the society's demands for the immediacy of the news without violating rights and the restrictions of the court.
I propose that we explore the need for the rule that was central to this incident involving the mistrial just a little bit more. So I'd like to have you try to imagine with me, Liz and Melissa, you specifically are there in the courtroom. You have permission to use the devices, various devices, to take pictures in real time. Let's say you're there. So now let's assume, remember the rule, you can't take an identifiable photo of a juror. And let's imagine you're complying with all of the rules as you're covering the proceedings, and you have a sneering witness, you have a flirting judge and juror, and you're you're trying to do the right thing, and all of a sudden, in response to something that the sneering witness says, another juror stands up and says, "Yeah, but he's guilty." Now, can you imagine yourself not taking a picture of that juror at that moment?
That's tough. Man.
It's not tough, but we can say what happened.
Yeah, exactly.
No rule against
So no picture.
what was said.
If that's the rule of the court, I mean, that's absolutely what I would abide by. No photo, but I would certainly report it to the T.
Okay.
You know, and as far as the flirting judge and juror, I would try to follow up on that as a separate story later, but I would still want to be within the confines of the court.
But okay, and I know we're all laughing about that particular example. But I will say this, I was called for jury duty once and was not ultimately selected for the jury, but it ended up becoming a very controversial case, particularly because of the judge's sentence. I used my maiden name on the air because I was unmarried for 4 years before I got married here, and my legal name is my married name. It's Brown. So when I got into the box to be questioned, the judge, who of course we'd worked with for many years, and so he just made a comment, "Oh, you're already trying to fool us. You're with your pseudonym here," and we joked about it for just a few seconds. But after that case became controversial, someone wrote a letter to the editor about criticizing the judge's actions and then brought up that example from jury selection. So you know, I guess it's not that off base that perhaps at some point there may be something that someone interprets as questionable.
All right, then.
But
oh, go ahead.
I was just going to mention something I've been meaning to mention. One very simple way that judges can address it is, sorry, people who are listening, put the camera on the same side as the jury box. Then you don't worry about them being in the background.
That was a typical.
Exactly.
And let me, and I know we're going to get into this more because I anticipate questions about the different, the variety of ways that this is interpreted and put into place in different courthouses and specifically courtrooms across the state. But part of the consideration on all of this is actually the physical layout of the courtrooms. Each courtroom is different, and each courthouse has, depending on its locale, can have 1 or 2 up to 20 different courtrooms, and each one is different, and each one is they weren't built for this day and age, for the most part, and so you have to kind of find space to make it not so obtrusive and just for the physical location of cameras. And I'm looking at that camera over there, and that's kind of was the size of the cameras. They were a little bit bigger when I was back there. And now that I've seen some that are just very, very small and actually physically take up less space and are not as obtrusive. So those are all kinds of just looking at the physical nature of what you're dealing with is an important consideration of how, again, the whole distraction that it can cause and maintaining the decorum of the court. So that's, again, one consideration that we make for this.
Those are very helpful points. We do want to explore that a little bit further in a moment, and there probably will be questions about that from our audience. Let me ask this, though, quickly of you, especially to start with, Liz and Melissa. Does it make sense to you that this rule, and that we're just picking the one rule for discussion purposes, but this rule that would prohibit photography of the jurors, does it make sense to you that rule is present when, in fact, everybody in the courtroom is fully capable of observing and identifying jurors who are sitting there? Now, what's the difference between allowing observers to see the jurors? The jurors don't wear hoods. They're not behind a screen. Their faces are right out there for all the observers to see. And what's the difference between that and taking photographs of them? How do you see that? I mean, couldn't you make the case that if they're observable in the courtroom, they should be observable to those outside?
You're correct. That's absolutely the case. I mean, whenever you've got an open courtroom, you're absolutely going to have the jurors available for anyone to see that's within the courtroom. I still am uncomfortable myself. I feel the level of responsibility that it's not appropriate to take the pictures of the jurors and disseminate those pictures during the trial. I mean, you've got the people within the courtroom, but I still feel that the perhaps possibility of danger to the juror becomes more imminent if it's set out there everywhere than they're there. What do you think, Melissa?
And that was the comment I made earlier, that it's an open courtroom so anyone can walk in and see them. It's just, because that is a good point. And you talk about the slippery slope of an open versus a closed courtroom, and why shouldn't we see those who are sitting in judgment of others?
But you must
it's
both
just one
have
of those that we don't do.
You both have the feeling, though, that the fact that it goes out and is a photograph available globally on the World Wide Web, something about that, even though you would like to have it all open, I think instinctively as journalists, you also recognize there's something that happens once it's a photograph that's available to the world, really, something that's not so good, something unsettling about that.
For the jury.
For the jury. Right. And that's what you were talking about too, Justice Rosen, I think, or at least alluding to. There's something about the availability of the photograph, the identity to the world that...
Well, again, you got to remember what the task is for a juror, and that's to focus on the evidence that's being presented at the trial, and then weigh that evidence against the jury instructions, which is the law of the case. And I would, that's what their task is, and anything that distracts from that is what we want to avoid. And I just think that if it's in the back of their heads or right up front that they're a part of the publicity of the trial, which they are just by their participation, but it goes further than that, then that can distract from that task. And, you know, the admonition is given at every single break that they're not to read the newspaper, they're not to go to the scene, they're not to do this and that. And that's required by statute to, in part, to create that environment and have them reinforce and understand that their task for the 2 or 3 or 4 or 2 weeks that they're in jury duty is that, and that alone. And so I don't know, and anything that would distract from that, I think, is what we're trying to avoid.
Okay. Comment, Liz?
Yes, this is actually more on a personal level for me, but I actually was on a jury last year. And I know, I mean, I can remember being on that jury and hearing some of the things on both sides, the prosecution and the defense, that absolutely shocked me. It wasn't a huge case, it wasn't a violent case, but it was a case, as is any, that was going to affect the future of this individual's life. And I can just picture that if there were a photograph taken of me at certain moments with that particular expression, I mean, I'm sure that I had those expressions, and it was not reflective overall of what I felt at the end of the day when I heard all of the evidence. But I would have rather not had that photograph taken while I was in the process of being a juror.
Justice Rosen, could we have a little bit of background from you about the mistrial, the concept of it? Maybe give us a little law lesson.
Remember, there's various reasons for a mistrial, and I actually have the statute here. But the one we're specifically dealing with, and remember, it's always a discretionary call for a judge when confronted with something that's prejudicial that happens in the courtroom. It's within his or her capacity under their discretionary powers to declare a mistrial. And the one I think we're really dealing with here this morning is prejudicial conduct inside or outside of the courtroom that makes it impossible to proceed with the trial without an injustice to either the defendant or the prosecution. And again, we're talking about criminal cases. That's true in civil cases and other types of proceeding. And so that's really the struggle that we're dealing with. And it really is a balancing that the court must weigh. First, the first task for the court when confronting some sort of prejudicial conduct, a juror getting up and saying he's guilty. Let's use that extreme example. First, there has to be a determination made, and I've had to do this numerous times, a kind of a balancing that's made by the trial court. Can this be cured by some sort of admonition to the jury? Pay no attention to the man behind the curtain, kind of a thing, or an instruction at the jury instruction phase that can cure. It's to the extent that some sort of admonition or instruction can cure the prejudice. And if not, then there's a weighing that takes place about whether the prejudice will result in an injustice. And you've got to kind of weigh that. And these, I want to say these are kind of objective terms, and these are things you can do. And really it gets down to the trial court's understanding of what the case is about. At what point in time did the prejudicial conduct occur? You get a feel for the impact. You get a whole different host of different things that occur when you're trying to weigh these things. And so that's, and I can't, and I saw Judge Brown, who's was going to be here this morning, and he's the one that did the mistrial on the, and I can't put myself in his shoes. I can't say where this was in the trial when this photograph was taken, what kind of warning was given to everybody who was using this form of communication. But all I can say is, in his mind, it met these thresholds, and he felt that an injustice would occur or did occur, that there's a reason for this rule and this prohibition. The prohibition was violated, and that was enough for him. Now, abuse of discretion is a very broad standard. It's the broadest standard that trial courts have. And another judge confronting the same question would not have been wrong had they had given an admonition or, expelled the reporter from the courtroom or done something like that. So there's very broad powers here. There's no right or wrong answer to these things, but those are the kind of the things that the court weighs, and they're very critical. And again, remember, and I'm glad you pointed out that how important it is, once you're at a jury trial stage, how important it is and how many lives the decisions that jurors make are impacting, and what the court is doing is significant. It's probably the most significant public service that one can do, except for maybe bearing arms to protect our liberty. I don't know, but it ranks right up there, and you don't really get that until you're there.
So under the standard that you've described, the nature of the case could be one of the variables that the trial judge would take into account. This happened to be a case in which one 20-year-old was accused of shooting and killing another 20-year-old. Really serious case. If it had been a lesser case, so you
know, again, those are all the things that weigh into it. You don't want to say one case is more important than another. I mean, I don't want to sit here and say that to you all. But if it's a theft case, a shoplifting kind of case where someone's demanding their day in court and it happens to occur, that might have a different impact on that juror's ability to decide or whatever it is versus a high-profile homicide case. I don't know. Again, those are the kind of things that you can weigh.
All right. We've touched it in one way or another on the initial topics we had in mind for this presentation. So, Ron, you're over there, and we have until 10:30. Isn't that true? 10:45. So we've got ample time yet to continue our conversation. But I would like to offer this. If you in the audience have any questions or would like to offer a comment in response to what we've covered so far, or as we go along from this point, if you have questions or comments you'd like to offer, please indicate. We'd like to involve you from this point forward. And so let me check. Is there anyone ready to? Yes, there is a question or a comment.
Thank you. You want to use the microphone? I can project this.
I think they want you to use it. Thank you. I'm glad Melissa brought up the point about the sort of the uneven application of the rules across the state. I think from where I sit, I'm with the AP over in Kansas City, and we often get frustrated by some of the different rules in the different counties. You know, we've covered a lot of cases, Great Bend, Topeka, Wichita, Hayes, where the rules are just too different and too vast. You never know what you're going to get until you get in front of the judge. And I don't want to say it's unfair because the judge has to set the rules in order to have a fair and orderly trial. But is there anything on the horizon to suggest that we're going to be seeing some sort of a baseline, some sort of a, I don't want to call it a standard for conduct, but what is going to be allowed? And I guess it seems to me it would be tough to do, right? Unfortunately, I'm one of those dinosaurs carrying around a BlackBerry today. It's a tactile experience, right? If you have an iPhone, it's a touch thing. It's very quiet. You can probably get away with tweeting or even just sending something back to your editing desk, and no one's going to be the wiser. But it seems to me that's some of the challenges involved here is what equipment do you let in? It's not just cameras. It's clickety keyboards that make too much noise and you know, keep the jury from hearing evidence or whatever. So if there's some way to address what is the standard, maybe what should be the standard, or what are some of the, you know, the dilemmas that judges face in trying to set up maybe their own rules.
And I would also appreciate Judge Rosen's perspective and taking that even a step further. What we've run into more than I can ever remember in the past year is the restriction of, oh, this witness doesn't want to be shown or recorded. And we actually, because at the end of the day, judge's discretion is still in those rules. It is up to the individual judge, no matter what that document says. And we actually did have an interpretation just this week at a trial that our station's very involved in, that initially the defense attorney said, I don't want my client even shown sitting at the defense table. And the judge initially agreed. The next day reversed course and said, well, okay, if he's on the witness stand, then you can't show or record that. But I would say that's something more than anything now that we're running into is even beyond equipment. What can you show, what can you not show? And it's different, not only from trial to trial, but within a trial itself.
Yeah, and I want to comment, you know, these rules are new, and I was impressed that the defense counsel in that case, I don't want to talk, that's the other caveat I got to give you, I can't talk too much about ongoing cases at all. But I can talk about scenarios in general. But, and the only way I know about this is from what I read. I think it was an account in the paper that defense counsel took a look at our new rule and noted that witnesses kind of have this power, not kind of have the power, but have the power to exclude their photographs and testimony being recorded. And I thought, you know, when we first did this, and I'll acknowledge this, I hadn't thought it through, and then when I saw that I thought it was a very creative objection to allowing his client to be testified to be photographed because he's a witness. I thought that's when we adopt new rules, when we're working on cases and we establish kind of a precedent or working along with precedent, there's always people out there who are going to look at this very carefully and think creatively. And I thought that was a very creative kind of way to look at it. And it got me to thinking, and Ron and I think the rest of us who are involved in creation of this rule got me to thinking, and kind of your point is, why is it that a witness in a proceeding has the veto power over this? And as I think about it, that should be the trial court judge. I'm just going to say that, being bold out here for the people across the state. But and I think that's one of the things I want to bring up and look at, because I don't quite understand.
We've had co-defendants.
Right.
So they didn't want to be photographed when they testified against a co-defendant.
Because they're witnesses again. So they can utilize this rule. So I think it does present a challenge, and I think that is one of the things I want to look at as we're going forward here, is really the inherent powers with the judge to control the courtroom and the proceedings, and why a party, the prosecution or the defendant or a particular witness, can have veto power over the court is interesting. And I just want to explore that more as to why we did that.
I'd like to help.
Or maybe you didn't think about it.
And I'd like to help you explore.
Yeah.
I offer now.
Let me talk about the equipment issue and all of that. And again, my experience is and again, we're talking trial courts because it's just not as much as an issue in this courtroom, or I think at the Court of Appeals. But again, we're dealing with 31 judicial districts, 105 county courthouses. Actually, I think there's 107. There's a couple of them that have two courthouses. And each courtroom presents its own particular challenges. Then you have the type of case that you're dealing with. And first of all, then you have a chief judge of that entire district who he or she is going to implement rules based upon this, or an understanding based upon this. And then you have the individual judges and district court magistrates who are going to utilize this. And it is difficult to get exact continuity from case to case because you're dealing with different concerns. As I mentioned earlier, my big concern at trial court was kind of the pretrial issues that arose. And I wanted a great deal of control over theirs. And I don't want to tell too many war stories, but there were times when the prosecutor got out of line and engaged in pretrial publicity, and the reporter would naturally cover that. And I recall having to delay my vacation by a couple of days because there was some sensational things coming out of the prosecutor's office that was getting covered. And you want to control those kinds of things. The reporter wasn't at fault for reporting what the objectionable conduct, but I had to put a gag order. And that's the other thing is that unfortunately there are times when you do have to exercise extreme control, contempt proceeding, gag orders, which offend me. And it should offend everyone, but that's what happens on occasion. But the point is, each case presents its own challenge, and so to kind of have this rule that's going to be general for everybody is difficult to do. And I think this allows enough flexibility that obviously you can bring equipment in and have that access. But I can understand also the frustration, and maybe one of the things that I'd like to hear is maybe Ron is our conduit to the court in terms of these issues. How big a problem is it, and what are we facing? Because maybe we need to address it with our chief judges, and we can do that. I mean, that's something we can do. But again, another example I can give you, it was in the late 90s. I think you'll remember the case. It had to do with it was an administrative appeal, a civil case having to do with the zoning of a Walgreens out at 37th. Remember that case? It got a whole lot of attention, and it's just a zoning appeal, and there was fairly sophisticated kind of complaints being made about it, and the community got all involved and up in arms about it. And that proceeding, it started when I was in a very small courtroom, and it wasn't attracting too much attention. And I didn't think about how, as it evolved, how much more involvement the community was taking in the case. And about 2 months later, I was in a different courtroom. Somebody had retired, and I moved to a different courtroom. And it was more accommodating. I said, sure, you can bring in cameras, because it was to me. But then all of a sudden, I remember I was taking evidence, and I allowed the cameras to go. It's a civil proceeding again without a jury. I allowed these big cameras like that into the courtroom, and there were 4 cameras in the jury box, just focused right on the bench. And I remember this just doesn't. This just isn't right. And so I allowed it for that particular proceeding. But it just, again, the kind of that was one of the times that I felt like this was kind of an intimidating kind of environment for me, just in how I was dealing with it. And I remember just thinking, in the future, I'm going to not allow that to occur. And so, I mean, things can happen. And so I guess my point is that each case, each courtroom, each kind of proceeding has its own challenges, and to kind of try to predetermine what those are going to be is difficult. So anyway.
Yeah. Well, I would think that it would be helpful, I think, for everyone if at the district court level, if the chief judges could somehow get together and talk about this, because some examples that we've encountered in Shawnee County, several suspects in a homicide case. Shawnee County is usually very good. They understand a first appearance comes up in 24 hours, so of course you're not going to have a week to give notice. And normally they're okay with that, and they say, okay, come on in. But one defendant, they said, yes, that's fine. Come bring your camera, show the first appearance. The next one, they said no. Same case, what's the difference? And those issues, and the whole issue now with the witnesses being able to decline video or audio. Of course, TV people, for a very selfish reason, we always want cameras in because we feel like we're at a disadvantage if we can't show pictures, because that's what we're all about. But on a very base level, though, it's that slippery slope when Justice Nuss talked about how we're so different from other countries and having this open judicial system. If you start disallowing that, at what point do we start having closed systems?
One other comment just about access. I happened to be in the district court, Shawnee County District Court last week for swearing in of a new judge, and I stopped by Judge Parrish's office knowing that I was going to be doing this because I was reminded that she had a trial, and I don't want to talk about the merits of the trial, but that was covered by, I think, 48 hours or 60, one of those. And I just asked her physically, how did that work? I mean, how did that occur? And she said it was very, according, and I don't want to take anything out of it, that it was unobtrusive, that the cameras were set up in the ceiling somehow.
They had equipment most of us in the state do not have. Robotic cameras that they installed, and they took several days to wire through the ceiling in the courthouse. Yeah. It was a very unusual situation.
Mike, we have another question.
But,
go ahead, Justice.
But anyway, the point being that again, with the advancing technology and I think Judge Fairchild had a similar case in Douglas County, which allow for this. But again, you know, it's a different kind of interaction when they're recording in that fashion. And I know, I imagine, I shouldn't say I know, I haven't talked to either one of them about this or their thought process, but I suspect that was their big concern, was how obtrusive is this going to be, and how is it going to be something that interferes again with the whole proceeding in the court process.
Question here? Go ahead.
You know, when cameras in the courtroom were discussed 30 years ago, one of the principal arguments was allowing citizenry to see what happens in a courtroom, so it was different from what you saw in a movie or watched in a television drama. And the thing that I guess bothers me a little bit about where the rules are today is, personally, as a broadcaster, I think it should be presumed that cameras and equipment are allowed in the courtroom, and then it should be up to the judge to back it off to a point where they think is reasonable. It seems it's the other way around.
To offer, by all means, do. Is there one here?
I just a quick follow-up.
Judge, just because you've brought this up a couple of times already, I had a question regarding access, and unfortunately it doesn't really deal with the electronic realm, so I'll leave this brief, sure. But it's brought up a couple of times in the past. We're dealing, I'm out of Wichita, and we're dealing with a case in Kingman County right now where some of, I believe it's limine hearings, if I'm pronouncing that incorrectly. Very good. Yeah, in fact, that's one of the things. Yeah, go ahead. And you seem to touch on this earlier, where these proceedings are not only being closed off to the media, they're being closed off to the public at large in this county under the argument that Kingman is one of the smaller counties in Kansas, and there is concern about, you know, obviously the jury pool being tainted, but Kingman, I believe, is 51st out of 105 counties. So if this argument were to hold water, that would mean more than half the counties in Kansas would be justifiable to just straight up close pretrial hearings to the public. And I just want to get your thoughts on that. And again, that's not all pretrial hearings. There are these come up in two different ways. Typically, it's motion to suppress, and typically it's confessions or things like that. But even more often in motions in limine, which means, and you'll hopefully be talking about this later in the day, I don't know that you will, but generally what occurs prior to trial is a defense or the prosecution will try to limit evidence that can come in because it's legally not allowed or it's prejudicial in the courts versus its probative value. There's kind of a weighing that goes on based upon what's presented and what's going to come into trial. Some of this stuff, and I have no idea what the Kingman case is or what you're talking about, but some of this evidence could be prior crime evidence that's completely irrelevant to the charge at hand, but if it's allowed in, could be very prejudicial to the defendant. And why does a prosecution request regarding, let's say, if you have a homicide trial and it's a drug conviction from 10 years ago, or actually, it could be more prejudicial if it's a sexual offense trial, a rape trial, and you're trying to get in prior conduct of the defendant regarding his relationships in the past. Some of that's allowed in, some of that isn't. Very sensitive material. And and the point about all of this is, it's not that information will not be eventually disclosed to the public. It's the timing of the information that's disclosed to the public. And my thinking about this, and again, in balancing access to information and all of that, is yes, there might be a delay in which that information is finally disclosed to the public or it's published or whatever. But what's, in terms of the balancing and the need for society to have fair and impartial trials, in weighing that, that's what I would consider. And I would I don't think I ever closed a pretrial proceeding, but I thought about it at times for that very reason. I probably had a little bit to do with Shawnee County being more populous than a smaller rural county. I completely understand the concerns that the trial court would have about some pretrial proceedings. That's to me where the real tension is.
Just a follow-up to that, though, if we're discussing potential evidence that may or may not make it into the courtroom to begin with, and the court proceeding is closed, and we don't even hear, the public, the media, no one hears about the potential evidence that the state has that the judge rules is inadmissible, then no one would ever know about this evidence because it would never be introduced at trial in a public setting. Now, this case specifically, it's a Kingman County where a former officer and a gentleman who was working at the law enforcement training, police training center is now on trial for homicide. So there's even more interest from the public in this because this is a state employee who's dealing in law enforcement prior to his arrest, and now we're dealing with a situation in Kingman County where there is evidence that the state has that because these hearings are being closed, there's no way that the public will ever know what these prosecutors tried to introduce that the judge ruled would be inadmissible.
And I just, because you're getting into a specific, and I'm really not one to avoid things. I'm really not, but I don't even want to broach comment on some of this because it's likely to come to us, and this is likely, could be an issue, and but I think I generally address the concerns, and I think ultimately stuff or information that comes out at a closed hearing doesn't necessarily mean it's forever closed, and all I would say at this point.
All right, well, thank you.
Again, I don't mean to avoid your...
I appreciate your comments, Connor.
Yes, I thank you as well for commenting as much as you could. What about this particular problem, going back to the question we had at the outset about the lack of uniformity in the rules as applied in various courthouses? Specifically, we've been thinking about the trial judge who may allow video and not audio. And I think you've encountered that, Melissa, or you're aware of where that's happened?
We've encountered about every combination that you can possibly think.
And do you typically, do you get explanations from the trial judges, or
No.
are you just mystified?
Well, I think it's under the guise of it's situational or it's sensitive. I mean, and there are generally accepted, I think that everyone in here can agree that usually children you aren't going to show unless they specifically say you can show. For example, there was a sentencing where the victim's daughter, I think, was 10 at the time, and gave one of probably the most powerful victim impact statements you can imagine. But they said up front, she wants everybody to hear this. But typically, children you wouldn't show, sexual assault victims you wouldn't show. But it's just like I was saying, an example of co-defendants. Co-defendants in the case decided, no, you can't show me on the witness stand, you can't record me. The argument that they tried to make would be because he was a witness, the defendant is in essence a witness to the activities, so therefore you can't show them at all, which ended up being overruled the next day. The decision was changed. So yeah, we've been in we've run the gamut. It seems there are certain judges that perhaps maybe are just inherently distrustful. We had a situation where a reporter in another county, not Shawnee County, was talking to someone on the phone in her Bluetooth, innocently commented to the person that she was talking to, man, this is really taking a lot longer than I expected. Well, a juror was walking by, thought she was talking to the juror, so the juror went to the judge and said, that reporter talked to me, which she didn't, and the comment was an innocent, well, the reporter was kicked out of the trial for a day before the judge changed his or her mind. I don't even know if it was a male or female. Just being ultra sensitive, and they did allow cameras in the courtroom once. Photographers sometimes when they're not shooting something, we'll just turn the camera to the side. Well, when he turned it to the side, it went in front of the jury box. The judge said, oh, you shot the jury. No, we didn't show the jury, but refused to believe that we didn't show the jury on this footage that never even aired or was streamed in the first place, even if they would have been. So, you know, again, it comes back to that trust issue and having good, being open conversations, I would think, as people in the media approach the judge or the judge's staff and be upfront with what you're looking for, be upfront with what those restrictions might be. On the other side, you know, I talked early on about training and how important it is to make sure that the newer folks who are doing either brand new to the business or brand new to doing a certain duty that maybe they hadn't done before, very difficult to train them when the rules are going to change every single time you walk into that courtroom.
I'm thinking about what you're saying in my role as the chair of the Kansas Bar Association's Media Bar Committee, starting to think, you know, it may be good if we could institutionalize some ongoing dialogue between the trial judges and the media, first so that the judges will maybe have an opportunity to understand things better than they do from the media's perspective, also so that the judges could share their reasons for some of the decisions they make, which, would you agree that would be helpful to have ongoing dialogue along those lines?
I would think so.
Okay. And I'll raise additional questions here acting as moderator, but don't hesitate to jump in, any of you in the audience, if you like. One issue that I thought might be worth touching on, at least, is the definition of those who are permitted to apply for the opportunity to use these devices. And we have in the rule this reference to the news and educational media. So the privilege to use these devices, it appears to be limited to those with that purpose, to disseminate news or provide education, using these devices to support those functions. And then we have this definition that includes reference to others, and it says, such as a publisher, editor, reporter, or other person employed by a newspaper, magazine, newswire service, television station, or radio station, who gathers, receives, or processes information for communication to the public, or an online journal in the regular business of news gathering and disseminating news or information to the public. So whoever that is, that's the person who can ask for the trial judge's permission to use one of these devices. What is your take on that as journalists? Does that particular definition of who can apply for permission, does that make sense to you? Is it helpful or what?
If anyone's ever been in the press box at a sporting event, you understand how anybody can claim their media. For TV people, probably a prime example I can give is at KU, to control how many people are underneath or are on our courtside during a basketball game. Cameras aren't allowed there anymore, you'll notice. They allow, I think every TV station gets like one game that they can be courtside. But then you see this whole line of still cameras, and you wonder, I mean, for us as TV people, we're like, well, I guess we could say we're taking photos for our website, and that would be legitimate if we really wanted to. How could they say no? Because they say yes to everybody else who's lined up there. So I would think, I don't know, Liz, how you feel about that, but it would seem like judges are probably going to have to start making that judgment, because in this era of, you know, we have some web-only folks here, and there are a lot of people who can say that they're a journalist if they have a blog or, you know, a column on a site. How many of those do you let in every single time?
I, again, am in agreement with Melissa, and this was one of the topics that we definitely discussed when I shared with other people at the radio station that I was going to do this today. And we all respect the fact that there are some very credible internet web-based journalists out there that do a terrific job and have a viable and important product. However, there are a lot who are not. And those bloggers, and wow, am I going to get myself in hot water here? They offend most of us true journalists, am I right, or am I right? And so I think it's going to be one of those situations that the judges do have to weigh on a case-by-case scenario as to whether or not they're legitimate. And on the other hand, you're not going to be able to weed out all of the bloggers who are not legitimate news-based types of situations, but then we as a public have to recognize, as Melissa said earlier, just who we're listening to or who we're reading or who we're seeing as to whether or not they're a credible news source.
Justice Rosen, could you?
I think part of the I'll call it expansive definition of who's included in this was intentional. So people who are doing an online kind of reporting at least have a mechanism to get to the court and say that they want to utilize the rule to record. And that was intentional. And we wanted to distinguish between kind of being expansive and inclusive of different types of coverage versus just the public at large. And that, it's a challenge. And if you have some suggestions to help us refine that, we'll certainly listen to them. But that's an ongoing challenge in terms of how we did this. Let me just tell you that part of the motivation to modify this rule is when we look back, I think it was September 1st, 1988, when we created the first rule, and it had been untouched since that time. So a lot has occurred since then, and so that's part of what, there are other things that occurred, some of the things we've talked about in our various courtrooms and even in this courtroom that caught our attention over the last couple of years, and it motivated the need to hopefully update the rule in a way that's useful.
Well, we'll need to close at this point, but oh, Ann, go ahead.
Well, it might actually be complicated. I was talking to one of our alums who was covering a quite famous trial in Florida, and he was telling me how he was tweeting during this trial, and people were tweeting back. And we've mostly talked about the dissemination of information, but what about information coming back into the courtroom through some of these electronic devices? And I don't know if that's ever happened to you as a reporter when you're in a trial situation and people are sending you information that may or may not have an impact on what is going on in the trial. And how do the rules handle that?
Well, we can only cover and report on what we're seeing there. Do you mean like as far as altering how you would report the trial?
He was telling me that people were actually writing in things like, you should ask about this.
Well, we can't ask anything, so really, you know, the commenters are going to be there, whether they are in real time coming in at replies or things like that. You know, that sort of thing, I don't think it wouldn't color how I would report the proceeding. And in a trial, the reporters aren't the one asking the questions. Sometimes you might get a reply and you'd be like, yeah, I want to know that very thing. Why aren't we getting to the point? But I don't think it would really color how I would. And that's the situation where, I mean, it's been an issue in a Shawnee County case on a juror who supposedly commented on a newspaper site in the comments section, and whether that should be grounds for a mistrial. Those replies on the tweets aren't going to be coming back to the participants in the trial, theoretically.
Exactly. Exactly. I don't think I could say it any better than just that. It certainly wouldn't color how I would report on anything. And I would hope that it wouldn't color how any responsible journalist would report on anything.
Two quick last points. Go ahead.
But that was very much a concern, at least of mine and other members of the court as we were doing this, is it's not a one-way communication exercise here, and we were very concerned about what's coming in and what's going out and how to address that. And I think we're very much aware of that. We even have that a little bit with lawyers who are arguing in this court. You know, they have a computer. They could actually be communicating with their law firms or with their offices on terms of the argument, and how we're going to look at that is another interesting challenge that we have facing us currently. So, no, that's the whole two-way communication aspects is a concern.
We have to close, although I wanted to mention at least 2 points. One is that the rule says that a violator, someone who acts contrary to the judge's grant of privilege, could lose the equipment. It could be confiscated. I assume there are other penalties that could be imposed, though. I mean, contempt is a possibility.
Yeah, contempt. I mean, the ultimate, I guess, and that would be, and it depends. Contempt takes two different forms. There's indirect contempt, which is kind of violating a court rule that you know is there, and direct contempt, which is more of a direct challenge to the court's authority. And if let's say a reporter is persistent in videoing someone in violation of the rules, has been warned, that would be more of a direct contempt, and very likely could land you in jail for a period of time, I would suspect.
So bring bail money with you, and
bail could be set pretty high. Could be set pretty high.
And you bring only cheap cameras into the courtroom. Then last thing, just quoting a line. It's interesting that this rule has a preamble that includes this line. It says the courts should champion the enhanced access and the transparency made possible by use of these devices while protecting the integrity of proceedings within the courtroom. But the interesting language, I think, is that the courts should champion the enhanced access and use of these devices. So
to me, it's protecting the integrity.
And to you, it's the other end. All right, well, thank you all for participating, and Ron, thanks for your part in arranging this. To offer, by all means, do. Is there one here?
Just a quick follow-up on that. Judge, just because you've brought this up a couple of times already, I had a question regarding access, and unfortunately it doesn't really deal with the electronic realm, so I'll leave this brief, but he's brought it up a couple of times in the past. We're dealing, I'm out of Wichita, and we're dealing with a case in Kingman County right now where some of, I believe it's limine hearings, if I'm pronouncing that incorrectly.
Very good. Yeah, in fact, that's one of the things. Yeah, go ahead.
And you seem to touch on this earlier, where these proceedings are not only being closed off to the media, they're being closed off to the public at large in this county under the argument that Kingman is one of the smaller counties in Kansas, and there is concern about, you know, obviously the jury pool being tainted, but Kingman, I believe, is 51st out of 105 counties. So if this argument were to hold water, that would mean more than half the counties in Kansas would be justifiable to just straight up close pretrial hearings to the public. And I just wanted to get your thoughts on that.
And again, that's not all pretrial hearings. There are these come up in two different ways. Typically, it's motion to suppress, and typically it's confessions or things like that. But even more often in motions in limine, which means, and you'll hopefully be talking about this later in the day, I don't know that you will, but generally what occurs prior to trial is a defense or the prosecution will try to limit evidence that can come in because it's legally not allowed or it's prejudicial in the courts versus its probative value. There's kind of a weighing that goes on based upon what's presented and what's going to come into trial. Some of this stuff, and I have no idea what the Kingman case is or what you're talking about, but some of this evidence could be prior crime evidence that's completely irrelevant to the charge at hand, but if it's allowed in, could be very prejudicial to the defendant. And why does a prosecution request regarding, let's say, if you have a homicide trial and it's a drug conviction from 10 years ago, or actually could be more prejudicial if it's a sexual offense trial, a rape trial, and you're trying to get in prior conduct of the defendant regarding his relationships in the past. Some of that's allowed in, some of that isn't. Very sensitive material. And and the point about all of this is, it's not that information will not be eventually disclosed to the public. It's the timing of the information that's disclosed to the public. And my thinking about this, and again, in balancing access to information and all of that, is yes, there might be a delay in which that information is finally disclosed to the public, or it's published or whatever. But what's, in terms of the balancing and the need for society to have fair and impartial trials, in weighing that, that's what I would consider. And I would I don't think I ever closed the pretrial proceeding, but I thought about it at times for that very reason. I probably had a little bit to do with Shawnee County being more populous than a smaller rural county. I completely understand the concerns that the trial court would have about some pretrial proceedings. That's to me where the real tension is.
Just a follow-up to that, though, if we're discussing potential evidence that may or may not make it into the courtroom to begin with, and the court proceeding is closed, and we don't even hear, the public, the media, no one hears about the potential evidence that the state has that the judge rules is inadmissible, then no one would ever know about this evidence because it would never be introduced at trial in a public setting. Now, this case specifically, it's a Kingman County where a former officer and a gentleman who was working at the law enforcement training, police training center is now on trial for homicide. So there's even more interest from the public in this because this is a state employee who's dealing in law enforcement prior to his arrest, and now we're dealing with a situation in Kingman County where there is evidence that the state has that because these hearings are being closed, there's no way that the public will ever know what these prosecutors tried to introduce that the judge ruled would be inadmissible.
And I just, because you're getting into a specific, and I'm really not one to avoid things. I'm really not, but I don't even want to broach comment on some of this because it's likely to come to us, and this is likely, could be an issue, and but I think I generally address the concerns, and I think ultimately stuff or information that comes out at a closed hearing doesn't necessarily mean it's forever closed, and that's all I would say at this point.
All right, well,
again, I don't mean to avoid your...
I appreciate your comments.
Yes, I thank you as well for commenting as much as you could. What about this particular problem, going back to the question we had at the outset about the lack of uniformity in the rules as applied in various courthouses. Specifically, we've been thinking about the trial judge who may allow video and not audio. And I think you've encountered that, Melissa, or you're aware of where that's happened?
We've encountered about every combination that you can possibly think.
And do you typically, do you get explanations from the trial judges, or
no.
Are you just mystified?
Well, I think it's under the guise of it's situational or it's sensitive. I mean, and there are generally accepted, I think that everyone in here can agree that usually children you aren't going to show unless they specifically say you can show. For example, there was a sentencing where the victim's daughter, I think was 10 at the time, and gave one of probably the most powerful victim impact statements you can imagine. But they said up front, she wants everybody to hear this. But typically children you wouldn't show, sexual assault victims you wouldn't show. But it's just, like I was saying, an example of co-defendants. Co-defendants in the case decided, no, you can't show me on the witness stand, you can't record me. The argument that they tried to make would be because he was a witness, the defendant is in essence a witness to the activities, so therefore you can't show them at all, which ended up being overruled the next day. The decision was changed. So yeah, we've been in we've run the gamut. It seems there are certain judges that perhaps maybe are just inherently distrustful. We had a situation where a reporter in another county, not Shawnee County, was talking to someone on the phone in her Bluetooth, innocently commented to the person that she was talking to, man, this is really taking a lot longer than I expected. Well, a juror was walking by, thought she was talking to the juror, so the juror went to the judge and said, that reporter talked to me, which she didn't, and the comment was an innocent, well, the reporter was kicked out of the trial for a day before the judge changed his or her mind. I don't even know if it was a male or female. Just being ultra sensitive, and they did allow cameras in the courtroom once. Photographers sometimes when they're not shooting something will just turn the camera to the side. Well, when he turned it to the side, it went in front of the jury box. The judge said, oh, you shot the jury. No, we didn't show the jury, and but refused to believe that we didn't show the jury on this footage that never even aired or was streamed in the first place, even if they would have been. So, you know, again, it comes back to that trust issue and having good, being open conversations, I would think, as people in the media approach the judge or the judge's staff and be upfront with what you're looking for, be upfront with what those restrictions might be. On the other side, you know, I talked early on about training and how important it is to make sure that the newer folks who are doing either brand new to the business or brand new to doing a certain duty that maybe they hadn't done before, very difficult to train them when the rules are going to change every single time you walk into that courtroom.
I'm thinking about what you're saying in my role as the chair of the Kansas Bar Association's Media Bar Committee, starting to think, you know, it may be good if we could institutionalize some ongoing dialogue between the trial judges and the media. First, so that the judges will maybe have an opportunity to understand things better than they do from the media's perspective. Also, so that the judges could share their reasons for some of the decisions they make, which, would you agree that would be helpful to have ongoing dialogue along those lines?
I would think so.
Okay. And I'll raise additional questions here acting as moderator, but don't hesitate to jump in, any of you in the audience, if you like. One issue that I thought might be worth touching on, at least, is the definition of those who are permitted to apply for the opportunity to use these devices. And we have in the rule this reference to the news and educational media. So the privilege to use these devices, it appears to be limited to those with that purpose, to disseminate news or provide education, using these devices to support those functions. And then we have this definition that includes reference to others, and it says, such as a publisher, editor, reporter, or other person employed by a newspaper, magazine, newswire service, television station, or radio station, who gathers, receives, or processes information for communication to the public, or an online journal in the regular business of news gathering and disseminating news or information to the public. So whoever that is, that's the person who can ask for the trial judge's permission to use one of these devices. What is your take on that as journalists? Does that particular definition of who can apply for permission, does that make sense to you? Is it helpful or what?
If anyone's ever been in the press box at a sporting event, you understand how anybody can claim their media. For TV people, probably a prime example I can give is at KU, to control how many people are underneath or are on our courtside during a basketball game. Cameras aren't allowed there anymore, you'll notice. They allow, I think every TV station gets like one game that they can be courtside. But then you see this whole line of still cameras, and you wonder, I mean, for us as TV people, we're like, well, I guess we could say we're taking photos for our website, and that would be legitimate if we really wanted to. How could they say no? Because they say yes to everybody else who's lined up there. So I would think, I don't know, Liz, how you feel about that, but it would seem like judges are probably going to have to start making that judgment, because in this era of, you know, we have some web-only folks here, and there are a lot of people who can say that they're a journalist if they have a blog or, you know, a column on a site. How many of those do you let in every single time?
I, again, am in agreement with Melissa, and this was one of the topics that we definitely discussed when I shared with other people at the radio station that I was going to do this today. And we all respect the fact that there are some very credible internet web-based journalists out there that do a terrific job and have a viable and important product. However, there are a lot who are not. And those bloggers, and wow, am I going to get myself in hot water here? they offend most of us true journalists, am I right, or am I right? And so I think it's going to be one of those situations that the judges do have to weigh on a case-by-case scenario as to whether or not they're legitimate. And on the other hand, you're not going to be able to weed out all of the bloggers who are not legitimate news-based types of situations, but then we as a public have to recognize, as Melissa said earlier, just who we're listening to or who we're reading or who we're seeing as to whether or not they're a credible news source.
Justice Rosen, could you?
No, I think part of the I'll call it expansive definition of who's included in this was intentional. So people who are doing an online kind of reporting at least have a mechanism to get to the court and say that they want to utilize the rule to record. And that was intentional. And we wanted to distinguish between kind of being expansive and inclusive of different types of coverage versus just the public at large. And that, it's a challenge. And if you have some suggestions to help us refine that, we'll certainly listen to them. But that's an ongoing challenge in terms of how we did this. Let me just tell you that part of the motivation to modify this rule is when we look back, I think it was September 1st, 1988, when we created the first rule, and it had been untouched since that time. So a lot has occurred since then, and so that's part of what, there are other things that occurred, some of the things we've talked about in our various courtrooms and even in this courtroom that caught our attention over the last couple of years, and it motivated the need to hopefully update the rule in a way that's useful.
Well, we'll need to close at this point, but oh, Ann, go ahead.
Well, it might actually be complicated. I was talking to one of our alums who was covering a quite famous trial in Florida, and he was telling me how he was tweeting during this trial, and people were tweeting back. And we've mostly talked about the dissemination of information, but what about information coming back into the courtroom through some of these electronic devices? And I don't know if that's ever happened to you as a reporter when you're in a trial situation and people are sending you information that may or may not have an impact on what is going on in the trial. And how do the rules handle that?
Well, we can only cover and report on what we're seeing there. Do you mean like as far as altering how you would report the trial?
He was telling me that people were actually writing in things like, you should ask about this.
Well, we can't ask anything. So really, you know, the commenters are going to be there, whether they are in real time coming in at replies or things like that. You know, that sort of thing, I don't think wouldn't color how I would report the proceeding. And in a trial, the reporters aren't the one asking the questions. Sometimes you might get a reply and you'd be like, yeah, I want to know that very thing. Why aren't we getting to the point? But I don't think it would really color how I would. And that's the situation where, I mean, it's been an issue in a Shawnee County case on a juror who supposedly commented on a newspaper site in the comments section, and whether that should be grounds for a mistrial. Those replies on the tweets aren't going to be coming back to the participants in the trial, theoretically.
Exactly. Exactly. I don't think I could say it any better than just that. It certainly wouldn't color how I would report on anything. And I would hope that it wouldn't color how any responsible journalist would report on anything.
Two quick last points. Go ahead.
But that was very much a concern, at least of mine and other members of the court as we were doing this, is it's not a one-way communication exercise here, and we were very concerned about what's coming in and what's going out and how to address that. And I think we're very much aware of that. We even have that a little bit with lawyers who are arguing in this court. You know, they have a computer. They could actually be communicating with their law firms or with their offices on terms of the argument, and how we're going to look at that is another interesting challenge that we have facing us currently. So, no, that's the whole two-way communication aspects is a concern.
We have to close, although I wanted to mention at least 2 points. One is that the rule says that a violator, someone who acts contrary to the judge's grant of privilege, could lose the equipment it could be confiscated. I assume there are other penalties that could be imposed, though. I mean, contempt is a possibility.
Yeah, contempt. I mean,
okay.
the ultimate, I guess, and that would be, and it depends. Contempt takes two different forms. There's indirect contempt, which is kind of violating a court rule that you know is there, and direct contempt, which is more of a direct challenge to the court's authority. And if let's say a reporter is persistent in videoing someone in violation of the rules, has been warned, that would be more of a direct contempt, and very likely could land you in jail for a period of time, I would suspect.
So bring bail money with you, and
bail could be set pretty high.
And you bring only cheap cameras into the courtroom. Then last thing, just quoting a line. It's interesting that this rule has a preamble that includes this line. It says, the courts should champion the enhanced access and the transparency made possible by use of these devices while protecting the integrity of proceedings within the courtroom. But the interesting language, I think, is that the courts should champion the enhanced access and use of these devices. So
to me, it's protecting the integrity.
And to you, it's the other end. All right, well, thank you all for participating, and Ron, thanks for your part in arranging this.